Good morning, everyone. I'm here with another chapter of Indian Polity, and that is center-state relations. We'll be doing it in two parts, just so that our understanding becomes clear and we need not rush into it. So, heading right into our discussion, this is my official Telegram channel, people. Any queries that you have, any concerns that you have, you can contact me here. You can also send in your PYQs from 2013 onwards in the PDF format of public administration. That is the optional that I teach. Along with that, you can send the 4GS as well as essay. Clear, people? Now, without any further delay, moving into our topic, the introduction. So, the Constitution divides legislative, executive, and financial functions between center and states. It is true, there is a clear division between what the center can do, the states can do in terms of legislative, executive, and judicial functions. And we have this as far as legislature is concerned or legislative subjects are concerned, we have this under the 7th schedule: central list or the union list, state list, concurrent list. Then we have an integrated judicial system where we have the lower courts, then the high courts, and above all of it, the Supreme Court. Center-state relation can be studied under three heads: legislative, administrative, financial. We are going to study each of these three heads. All right. So, heading to our discussion first with legislative relations. It starts from Article 245 to Article 255 in Part 11. There are four aspects in the central state legislative functions. The first one being territorial extent of central and state legislation. Like, what is the territory? How far can state frame a law? How far can center frame a law? When we talk about the parliament, they can basically make law for the whole or part of any territory of India and even pass a law that is extraterritorial, beyond the territory also. So that power vests only with whom? The parliament. When it comes to state, whole or part of the state, that is within the territorial jurisdiction of the state only, legislative power of the state exists. Laws of parliament are not applicable in. So exceptions are there, where laws of the parliament are not applicable. This is predominantly with regard to the scheduled areas and the scheduled tribes. Let us look into that. President can make regulations for the peace, progress, and good government of Union territories of Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, and Daman and Diu and Ladakh. President can make regulations for Puducherry when the assembly is suspended or dissolved. Taking it further forward, regulation has the same force and effect as that of an act of parliament. It may also repeal or amend any act in relation to these union territories. Means what? So if the president actually makes a resolution here, it has the same effect as that of a parliament. And not only that, they can also, the president's resolution can change, amend, make whatever changes they want with regard to an already existing law of the parliament when it comes to the administration of these areas. The governor is empowered to direct an act of parliament does not apply to a scheduled area in the state or apply with specified modifications and exceptions. The governor of Assam has the same powers. That is, with regard to Assam, governor can say an act of parliament does not apply to Assam. Governor can decide here. The president has the same powers with regard to tribal areas in Meghalaya, Tripura, and Mizoram, especially the autonomous districts. Clear, people? So, what do we see here? We are basically seeing that the whole concept here is that even though parliament has extraterritorial powers, there are certain exceptions. Parliament's power to make law or frame law has certain limitations when it comes to union territories, when it comes to scheduled areas, when it comes to Assam, when it comes to Meghalaya, Tripura, and Mizoram. In the case of Assam, governor has maximum powers. In the case of union territories, it is the president. In the case of Meghalaya, Tripura, Mizoram, it is the president again. Clear? Distribution of legislative subjects. Parliament, Union list. So, originally it was 97, currently it is 98. State list. Originally it was 66, currently it is 59. Concurrent list, originally it was 47, now it is 52. Whatever I have given in the bracket, that is the original number of the subjects. Taking the discussion further forward, 42nd Amendment Act transferred from state to concurrent a few subjects. What are they? Education, forests, weights and measures, protection of wild animals and birds, administration of justice. 5 topics: education, forests, weights and measures, protection of wild animals and birds, administration of justice, the constitution and organization of all courts except the Supreme Court and the High Courts. 101st Constitutional Amendment basically added GST. Residual subjects. Any subjects which are basically not mentioned in the union list, state list, concurrent list, etc., whatever we consider as the residual subjects, only the parliament has the right to frame laws under it. USA. How the parliamentary system varies, or the legislative powers varies between India and USA. So USA has a federal government which is clearly given in the constitution, and the residuary powers there rests with the states. It is up to the states to decide whether they want to frame a particular new law or not. In the case of Australia, it is just as same as USA. Canada. Now you must understand, the easy way to remember Canadian system is, most of the centralizing features what we see in our constitution, we have borrowed it from Canada. Therefore, no surprises here. It is also federal. We have provincial subjects, etc. Everything is there. But ultimate power lies with whom? With the center. State law will prevail if the bill has been reserved for the president and received assent. That is, generally in the concurrent list, both union government and state government can pass a law. But in the event of a clash, whose law will stand above? That is the question. If the state law will prevail if the bill has been reserved for the president and has received assent. That is what the constitution says. But you must understand here, the parliament is still powerful enough to pass a law that will come above the state law. Parliament can still pass a law on the subject which will have the superior position compared to the state law. But if the parliament doesn't pass such a law, then in such a scenario, state law will prevail. Getting the point here? In the event of a clash between union law and state law with regard to a concurrent list subject, if union has not passed any law, state law has been reserved for the president gives the assent, state law will prevail. But if the union later decides to pass a law on the same subject through the parliament, then the law passed by the parliament will stand above the state law. Clear, people? Moving on. Parliament legislation in the state field. Next $1,000,000 question is, can parliament pass a law with regard to a subject which is there in the state list? They can, in exceptional cases only. So what are those cases? When Rajya Sabha passes a resolution. So this resolution, if Rajya Sabha passes a resolution with 2/3 of the members present and voting, 2/3 of the members present and voting, they pass the resolution, means then Parliament can make a law on state subject which will be valid for 1 year, and you can keep on renewing it. This is done in national interest with respect to GST or any subject within the state list. Law cease to have effect on the expiration of 6 months after the resolution has ceased to be in force. So this resolution has to be kept on renewing. So it means only one thing. If the Rajya Sabha passes a resolution, it does not have a permanent effect. Getting the point? If you stop renewing it, then it will only have, from the last date of renewal, maximum up to 6 months only, That law will have effect. After that, the law won't have any effect. And this should be passed by 2/3 of the members present and voting. This can be with regard to GST or any other subject in the state list. During a national emergency, again, with regard to GST or any matter in the state list, Parliament can pass laws. Law becomes inoperative 6 months after the emergency has ceased to exist. Automatically. So, whatever laws are passed by the Parliament during the time period of emergency, it is valid. Any act of omission, commission done during such a national emergency cannot be even questioned in a court of law. That is the point, because a law was passed by the Parliament and you are executing the law during national emergency. Once the emergency stops, all right, then how long can this law exist? Maximum 6 months. When states make a request, if 2 or more states pass a resolution, then again Parliament can pass a law with regard to the subject for which the resolution was passed by the state. Laws so made will be only applicable to the states which passed the resolution. That means if the state of Kerala and Tamil Nadu passed a resolution asking center to make a law with regard to a particular state subject, the law so made by the Parliament will be only applicable in the state of Kerala and in the state of Tamil Nadu. Clear? Moving on. To implement international agreements. Again, all the environmental related treaties, if the government wants to implement it, they can easily implement it. That is, Parliament can pass a law with regard to a matter in the state list if it is to give effect to an international agreement. The next condition is what? During President's rule again, Parliament can pass a law with regard to a subject in the state list. Law will continue to remain in effect until repealed, altered, or reenacted by the state legislature. What does that mean? In other cases, we saw automatically after the resolution has not been renewed, from that date to 6 months. National emergency, 6 months. Here, that is not the case. If the Parliament passes a law during a President's rule, that law will continue to remain in effect until it is completely repealed, altered, or reenacted by the state legislature. During a President's rule, center will have control over state legislation. Governor can reserve the bill for President. President has absolute veto over such a bill under Article 200 and Article 201. That is, any bill that is being passed, Governor can reserve it for the President. A state bill imposing restrictions on the freedom of trade, commerce, and intercourse with the state or within the state can be introduced in the legislature of the state only with the previous sanctions of the President. That is, any restrictions with regard to trade, commerce, intercourse, anything that you are planning to do, you can introduce such a bill only with the previous sanctions of the President. Reserve money bills and finance bills for the consideration of the President during financial emergency. That is the next thing. That is, if a financial emergency is in place, Governor again can reserve what? Money bills as well as finance bills for the consideration of the President. Because when a financial emergency is in operation, you cannot simply go on spending money. So whatever expenditures that you are planning to do, you need to get the permission of the President, or in other words, the union government basically. Taking the discussion further forward, Governor cannot make ordinances without the instructions from the President in certain cases. So the law-making power of the government, all state government also, is not entirely that they can do whatever they want. It again depends. In certain matters, they will have to keep the President informed. All right, people. Coming to administrative relations. Article 256 to Article 263 in Part 11. Distribution of executive powers. Center, whole of India, they have executive power, especially with regard to matters of the union list. Exercise of rights, authority, and jurisdiction conferred on it by any treaty or agreement. That is, center has the executive power to give effect to any treaty or agreement. When we talk about the executive power of the state, it is largely confined to what? Territory of the state. Concurrent list. Though law is passed by parliament, it is executed by the state except when a constitutional provision or a parliamentary law specifically confers it on the center. Means what? In the matters of concurrent list, I told you already, center has powers when you see over the state to pass law. But passing law is one thing, executing it is another thing. Center cannot literally come and tell the state or do all the work. Take law and order. Now, very recently, center made changes to CRPC, IPC, Indian Evidence Act. Correct? Now, who is going to execute all of this? The state governments. Getting the picture here? That is what we say. Law can be passed by the center. Execution is done by the state. Obligation of states and center. Executive power of state. Compliance with laws made by the parliament. Not to impede or prejudice the exercise of executive power by center. What does that mean? So whatever executive power of state is given, there are two conditions that they should never tamper with. The first condition is compliance with the laws made by the parliament. They should not try to violate the laws that are framed by the parliament. Number one. Number two, not to impede or prejudice the exercise of executive power by center. That is, they should not impede or block the executive power of the center. If that is the case, then if they do any one of this violation, if they violate, Article 365 will kick in. Because Article 365 is very clear. If any one of this gets violated, then President's rule can be declared in that state under Article 356. Clear, people? Moving on. Center's direction to the states. The construction and maintenance of means of communication. Protection of railways within the state. Instruction in mother tongue at the primary stage of education to children belonging to linguistic minority groups in the state, drawing up and execution of the specified schemes for the welfare of ST in the state, coercive power of Article 365 is applicable everywhere. What does it mean? That means, let us say a state fails to maintain the means of communication, or they are not even doing it. A state fails to protect the railways, fails to give instruction in mother tongue, especially for linguistic minority groups in primary education, drawing up and execution of specified schemes for the welfare of the scheduled tribes in the state. None of these are being done by the state means, it simply means what? Article 365 has been violated and therefore Article 356 can be imposed there. President's rule can be declared. Mutual delegation of functions. Delegation of executive functions. Inter-government delegation. President with the consent of the state government may entrust to the government any of the executive functions of the center. That is by mutual consultation. That is, President will consult with the state government and ask them, can you do this function of the center? Similarly, Governor can entrust the center executive functions of the state. It's a mutual understanding. Parliament can delegate executive function to state. No consent is required. Why? By law. By law, Parliament can make a law where they say that this work will be done by the state. They can do that. However, state legislature cannot confer powers and impose duties on the state by legislation. Getting the point here? By mutual consultation, President can ask the state government, can you do this work? And give the executive power to the state. Similarly, Governor also can ask the central government by consent, can you do this work of the state? Can you do it? State can ask center also. This is okay. But when we talk about law, by law only Parliament can delegate executive powers to the state, not the other way around. State cannot pass a law asking the center, come, you do this work. That they cannot do. Clear? Cooperation between the center and the states. So from this point onwards, we will take it up in our next class. All right, people, have a fantastic day. So this was the end of part 1. We will continue part 2 in our next class. Once again, this is my Telegram channel. Any queries that you have, you can ask it over here. And with that, we come to an end of the first part of center-state relations. Take care.